Hi, thanks for joining us again to do one of our podcasts. This time it's going to cover solicitor client assessments. Over to you.
Thank you. Another Clarion update, and hot off the press too. This is this new warfare that's going on between solicitors and clients. Why is it happening? Well, of course, Sir Rupert Jackson, who is also now a Clarion broadcaster, Sir Rupert Jackson brought about the ending of recoverability of additional liabilities. We've also got fixed costs in lower value injury cases, and the truth of it is that solicitors acting for claimants are being squeezed. And because their cost recovery is so diminished, they are now, understandably, looking to the client to make up the shortfall. But clients don't like paying out money. And the practice has been exacerbated, this concept, by solicitors actively advertising challenges and saying, have you had deductions made from your costs? We will seek to recover any over deduction or challenge what has been taken so that you actually get more money than initially you received. And just put things in context, we had the Court of Appeal case of Herbert, which I attended in person. And in Herbert, the Court of Appeal said that when it came to deductions, there has got to be a very clear understanding and acceptance by the client. There must be an informed consent as to the deductions made. Then we've had a case called Belsner, a decision of Miss Justice Henderson, who is also responsible for the latest decision that Joanne is going to mention in a moment. In Belsner, which is going to the Court of Appeal, Ben Williams QC, fabulous cost silk, has been taken on board. It is definitely going to the Court of Appeal. And that was a rather unusual case because what the solicitors did, they acted again in a modest road traffic injury case, and their retainer said that they could take more from the client than would be merely recoverable from the other side, so that there was an inter partes cost liability, but unusually there was no cap on the amount of costs that they deduct. And most solicitors say, the maximum we'll take will not exceed 1/4 of your damages. So the judge took a very odd view, I think. We'll see what the Court of Appeal make of it. But I think it is, my view, for what it's worth, is that Belsner is going to be reversed in the Court of Appeal, saying that there's a fiduciary duty to look after the client when you are actually taking them on. Well, that is, I think, unsustainable, because a fiduciary duty kicks in when you are acting, but when you are saying to the client, we are prepared to act on these terms, that is a very different proposition. So I think Belsner is highly likely to be overturned. But anyway, we've had another decision, and we are going to hear about it now from Joanne. And it's an unpronounceable case, but I think we've had a stab at what it might be called, but I'll let Joanne reveal it to the world.
So we've gone with SGI Legal against Karatysz. That's what we're going to pronounce it from there. Yeah. Yes. So just by way of background, this was a RTA case where the claimant sustained whiplash injuries. It was submitted, she instructed SGI Legal to recover damages on her behalf, submitted through the MOJ portal, and she recovered £1,250 damages. Now, she instructed SGI Legal on a CFA, and within that CFA, there was provision, and I'm going to read it out from the judgment. There was provision that the costs which are chargeable under this agreement will most certainly exceed those fixed costs. There's a clause above that says fixed costs will be sought in MOJ cases. And so you'll be required to pay the shortfall from your damages. It goes on to say, this warning having been given, you permit payment to us of an amount of cost greater than that which you can recover from another party to the proceedings. So this was a CFA where it was set out the terms on which she was engaging SGI Legal to act for her, and there is that statement there that says she agrees to it. So fast forward, the SGI Legal took 25% of her damages, which was a provision within the CFA. So they recovered the fixed costs from Aviva Insurance, and then they recovered 25% from her damages as way of success fee and then the ATE premium. Now, the client, she wasn't happy about this. She wasn't happy that her £1,250 had been reduced, and therefore she issued a solicitor client assessment under Section 70. So that then went to the Sheffield District Registry of the High Court, where in the first instance, DJ Bellamy found two things. He said that he limited the amount of cost payable to that recovered from the insurer, and also as a result that had reduced the bill by greater than 20%, which meant that the solicitor then had to pay the cost of that assessment. It all fell down on what is informed consent under CPR 46.9 3C2. So this went to an appeal. SGI appealed the decision, and actually on appeal they looked closely at what is informed consent, and it was, I'm just going to read again another part. It says the defendant's solicitors were successful on appeal. Mr. Justice Lavender held that the issue under CPR 46.9 3C2 is whether or not the solicitor told his client what is there set out. That issue concerns what the solicitor said, not whether the client agreed with or approved what the solicitor told him. So that is the key point. And if we go back to the clause in the CFA, the client was told about those reductions. Therefore, SGI was successful on appeal and they were entitled to recover the reduction or the percentage recovery from the damages. It then also went on, a second part of the decision dealt with who pays the cost of that assessment. And Justice Lavender found that the 20% reduction comes from the amount of the bill to be paid. So it wasn't the higher figure that was presented and then a cap applied. It was the amount that was presented to the client to be paid. That did not exceed 20%, and therefore the defendant did not have to pay the cost of that assessment. So that is a quick summary of quite a complicated judgment to wrap your head around the maths, but when you take away the maths element of it and you look at the principal decisions, it all falls down on, it all comes down to what is informed consent.
Yep, absolutely. I couldn't agree. That's a perfect summary, may I say. And the point that you mentioned about, the point that you mentioned about the costs of assessment in Herbert, where they were arguing about £350, the costs of the assessment were over £4,000 at first instance, and that's something that is not generally or widely necessarily appreciated. Cost specialists like you will know that, but in the wider world you think, well, if we're arguing about £300, it can't be proportionate to spend 13 times more on the bill. But that's a really important point of principle, and I think we've a breath of common sense, I think, in this case, because it is clients agree. And she was told what for in the clearest of terms. And it wasn't as if there was anything untoward, as there was in Herbert, where they set a maximum success fee in circumstances where the risk was negligible. They set 100% success fee so they could make the maximum deduction in circumstances where the correct success fee, said the DJ, at first instance was 15%, because the case, frankly, was unlosable. So that is pressure. And I appreciate that clients need to be given guidance, but everybody recognises that, and it's a contract, that when you are acting for somebody, what you get from the other side, if you think in ordinary litigation, on the standard basis, there is always inevitably a shortfall. It can be a big shortfall. So the idea that you can say, well, all you ever get is what the other side pay you. If that is inadequate to do the job, that is arrant nonsense. So a breath of fresh air. Yeah,
absolutely. So thank you, Dominic, for running us through that. And
thank you for explaining that difficult case, because it's a head bender.
Summary. Yes, it is a head bender. So thank you. Take care until next time.
Right. Thank you.